One thing that has caused some concern for particularly tax advisors just recently, the Mehjoo or Harben Barker case heard in the courts recently, which has been seen by some people, some commentators, as a very worrying development for tax advisors, particularly those advising on tax avoidance, tax planning, a case involving a dispute between a client and an advisor about whether or not the advisors ought to have offered their client the use of a particular tax avoidance strategy, scheme, call it what you will, a few years ago, which could perhaps have saved the individual a large amount of tax by taking advantage of his apparent non-UK domiciled tax status. Reading the case, it would appear that the advisors didn't offer their client this particular scheme, strategy. It's not clear exactly what the reasons for that were, but the question arises, were they obliged to offer that individual the benefit of that scheme or make that person aware of that scheme at the time? It would have identified for him a possible tax planning strategy which would have apparently saved the individual a large amount of tax. But it was, from the look of it, a fairly artificial, some would say a very extreme tax planning, tax avoidance scheme. Some commentators have said that the judgment in favour of the client in the court makes it very difficult for advisors to decide what they are obliged to make their clients aware of or what they're not obliged to do. Are we obliged to make them available to them all tax planning strategies that are around at any particular time, no matter how extreme they are? Or is it more that advisors need to be more careful about making the terms of their engagement very clear with their clients in future? I think the more common sense line is that is exactly the point, that advisors need to be aware of their own limitations, need to be aware of their own particular areas of expertise or areas that aren't within their expertise, and to make it clear as regards the terms of engagement with a particular client, what they are expected to offer that client or what they're not expected to advise on. It certainly has, as a particular decided case, sent shivers down some people's spines as regards their obligations to their clients. Other people have adopted a more even keel approach and said that it's not that serious, that perhaps as long as your terms of engagement are clear and you know your own limitations and your own expertise as an advisor and are prepared to hand the client on to other advisors, at least perhaps to make them aware there are other advisors out there who specialise in specific, maybe more deliberate tax avoidance planning, and that's sufficient. The case is probably going to be appealed, and it may go a long way in the courts before we know the final outcome. Certainly one to keep an eye on from an advisor's point of view and from the client point of view as regards what an advisor's obligations to their client are and how clear their terms of engagement are for the future. So the Mehjoo case, some people see it as a worrying development, others are more sanguine about it and take the view that this is a question of clarifying the advice which a particular advisor is expected or indeed capable of giving, and at least being aware that there are other advisors out there and other scheme providers, sponsors who may be useful in any particular set of circumstances.